thank you all for joining today's Research America Alliance discussion. I'm Russ Paulson. I'm the President and Chief Executive Officer at Research America. Thanks for your partnership. If you are not a member of Research America, please feel free to join. We would love to have you. There's the QR code, and anyone is welcome. Your organization or you as an individual are welcome to join. So we've been doing calls, Zooms, Teams meetings, all sorts of stuff um, since the Monday after a proposed rule was dropped by OMB. We started having conversations. And so many times in those conversations, somebody asks a question, and one of us, whoever's speaking, has to say, "Well, I'm not a lawyer, but what can we do?" And we didn't have a lawyer until today. Today, we actually have two lawyers. One's on right now. We'll have another join soon um, to talk about their analysis of the rule and answer your legal questions. We also have Yvette Seger, who I think is finally able to connect. She's been having some connectivity issues. Yvette has written more than her fair share of comments. It's important that we write comments well because they will, even if OMB doesn't agree with our comments, they form the basis for potential legal action and arguments after the fact. So we've got to get the comments right. As I have said before, there is no prize for fast. There is only a prize for doing it well. And even then, the prize is could take a minute to get to, but we need to do these comments well. And some of us took the interim step of asking for an extension from the OMB. This is a kind of a not atypical thing to do, and it's really expected when a rule this broad and material is proposed. Some of us have started getting replies to our request for extension just yesterday saying, no, we're not going to give you an extension. So it is time to start writing those comments. We had just the 45-day period. So now is the time to start writing the comments. We do have some resources for that, but we also have some live resources right now. And if you could put your questions in the chat. This is sort of a webinar format and not a thing where we can all see all 430 some of us. We know we had 700 people sign up for this event, so we'll probably even grow more. This is being recorded. A lot of our conversations are off the record and not recorded. This one is being recorded, so be aware that it is on the record. Put your questions, comments in the chat. We'll talk more. We'll answer your questions as soon as we get done with a little bit of presentation on how to. So with that, I will turn to Yvette Seger, who has, as I said, written more than her fair share of comments to proposed federal rules. Yvette, over to you.
Russ, thank you. And I apologize for the tech issues on my side. I have gotten to the resolution of my cell phone. So many thanks to Jacqueline for taking care of sharing the slides. And yes, it is true. I have written a few of these comments in my day, and I don't think I'll ever stop.
Okay, I think it's ironic that Yvette said that she would never stop, and somehow her tech has stopped her. So we're going to keep working on Yvette's tech issues, but I think we're going to jump ahead. Jacqueline, if we could jump ahead, please, to Leslie's slides. As I mentioned, so many times we've had questions that are really more appropriate for attorneys. And we actually have two attorneys with us, one right now, and her colleague, Mark, will be joining us shortly. But Leslie, you've done two things. You've done a deep analysis on the OMB proposed rule. It was amazing how quickly you all did a very thorough and non-hyperbolic review of the rule, proposed rule. So if you could take us through the substance, and then folks have questions about process, about substance, about what happens after. And I think you and Mark are kind of experts in that as well. So if you'd be willing to take questions after we're finished, that would be great. I will turn it over to you now, though, to kind of go over the substance of the rule.
Perfect. Well, I appreciate that intro, Russ. And it's good to be with you, everyone. Again, I'm Leslie Thornton. I'm counsel based in Los Angeles at Ropes and Gray. My practice focuses on all things research and development. And so the uniform guidance is something that's near and dear to my heart since 2013. And soon, as Russ said, I'll be joined by my colleague Mark Barnes. He's in a meeting that'll just be breaking shortly, and he'll jump on with us. Mark and I also bring unique perspectives. I was actually a researcher in a prior life, so I've actually applied for and been under federal funding and operated with federal funding. Mark also has held some administrative positions in the research world. So we not only come to this as lawyers, but also with those different perspectives. Just a caveat here that obviously, our presentation here is really meant to help your understanding of the proposed rule and what you might want to put into your comments, but this is not legal advice from Ropes and Gray. So you want to make sure that you're consulting your individual institutions, legal counsel, or if we are your legal counsel, then obviously you can come to us separately. And then as Russ said, you'll have an opportunity to ask some questions. So if we can go to the next slide. Here, I'm really just going to spend about, I'm going to aim for around 10 minutes just to remind us of what's happening here and some of the salient or more material provisions that OMB is suggesting should be revised through this proposed rule. So there are really three main objectives that OMB is citing. They say that they want to improve transparency, accountability, and oversight. They want to clarify the regulatory status of Part 200, and they want to reduce burden. So pausing here, I think it's really important when we're starting to talk about your comments that if you think that a proposed revision does not achieve these main objectives, you should specifically call that out. And I think there are many things that are actually potentially reducing transparency, at least relative to awardees, and really putting more burden on recipients. And so just keep that in mind. Do you want to keep going back to these objectives? You can point that out in a global way, but you can also point that out in your comments more specifically when you're ticking through each of the proposed revisions. And then just a reminder that a lot of what's in these proposed revisions, we've seen over the last year and a half since January 2025, since Trump 2.0 has been in office. A lot of this is really just putting into regulation what we've seen in executive orders and various memoranda on topics like DEI and other topics that are disfavored by the administration. And also what we've seen around just federal grant making too. So we saw last August, the grant making EO came out, and a lot of what we're seeing in these revisions is literally just a cut and paste from that prior EO. If we can go to the next slide. So this is some of the key themes of these revisions. We're trying to kind of distill down this kind of behemoth revision into some salient points. So one is really, this is shifting from guidance to regulation, and we'll talk a bit more about why that's important, and that's going to have a big impact on future rulemaking after this rule is finalized. Really, this is aligning the awards with the current administration's priorities, but obviously the way it's written is not specific to this administration or this political party. And so we have to think about the implications down the road when the administration changes. And also this is making grants and cooperative agreements more contract-like. Again, we'll talk about that a bit more, but it's really taking concepts that we see in the Federal Acquisition Regulation and the FAR and porting that over into the grant and cooperative agreement context. And then finally, adding non-scientific policy restrictions. So there's a lot of terminology we're seeing that's undefined and concepts that are undefined that are allowing that will allow, if passed as proposed or adopted as proposed, would allow a lot of discretion, even more discretion for awarding agencies. And then we can go to the next slide. So on these slides, again, I'm just wanting to give you a very high-level overview. Hopefully this will spur some additional questions on your end that we can talk about in a bit. But just to remind you, so again, this is going from guidance to regulation. So future OMB amendments, so beyond what we're looking at here with this proposed rule, would essentially take effect government-wide on a single date. So OMB is saying that agencies will remain partners with OMB in any future amendments process, but we really don't know what that would look like. And we see this as OMB is trying to fill some gaps that it sees and problems that arose on its end over the last year with all of the award terminations. So we saw that there were there was disparate language between, for instance, what the uniform guidance said and what like HHS's codification and regulation when they were adopting the uniform guidance. That language actually differed because HHS was behind in updating it. And so that caused some confusion, and it was the focus of a lot of folks who were challenging terminations last year. Also, there's a new specific conditions authority that basically new language added here. So it's really giving agencies more flexibility to add or remove specific conditions throughout the period of performance. So they could look at a risk assessment of the recipient, their history of compliance, and basically decide we need to add additional conditions to this award. And once they make that decision, they're proposing that those changes would need to be implemented within 15 calendar days of that determination, which obviously that's a huge lift for many institutions, particularly depending on what the actual action is that they're requesting be taken. They also give new examples of conditions that can be imposed. So this is not totally new. Some of this language existed in the types of conditions that could be imposed, but they added new examples. So they may ask for finance reporting on payments to contractors and vendors. That's a big focus of them on subawards and subcontracts. And also around financial integrity related site visits. They could actually require that. Next slide. So pre-issuance review, and this is really one of the biggest ones. So agency designated senior political appointees would conduct pre-issuance review of all discretionary awards. So this is really inserting a political appointee into the grant review process. So, and it's basically all phases. So it would be, looking at the proposal that would be sent out to the community requesting like a federal opportunity announcement. Then it would also be in reviewing the awards, and then also once the awards are actually provided or given out over the lifetime of the award. And so it basically says that these agency designated folks, these political appointees, would need to advance the president's priorities, could not promote anti-American values, again, another term that's not defined, and expressly says that peer review recommendations would be advisory and shouldn't be just routinely deferred to by those appointees. So we can talk more about that, but this is a really salient point that's really going to be a fundamental change in the review process of awards. There's also an expanded list of items for consideration. So as your applications are being reviewed, agencies would be asked to look at financial capacity, which actually is not completely, that's not a totally crazy idea, right? If you're an entity that's only received an award for $1 million and you're asking for something for $500 million, it's reasonable for the grantor to say, are you able to actually handle this level of commitment? Some of the other things here that are added are a little bit more squishy, let's say. So they have this new concept of a history of questionable practices. So they give examples of plagiarism, studies that can't be replicated, that kind of thing. So almost kind of a research misconduct angle. But those are only given as examples. So, potentially agencies could try to fit more into that history of questionable practices. They're also going to need to look at memberships and affiliations of the applicant to see if the applicant is affiliated with some institution or entity that's violating federal law, et cetera. Now, that's difficult because we don't know how attenuated the relationship would need to be, right, to invoke this. And many of you belong to very large institutions that have lots of memberships and lots of affiliations. So again, the lack of definition here gives a lot of discretion to the agencies. Okay, next slide. Also, one of the goals OMB says is that they want to streamline the award process. Some of the ways they say they're going to do this, they want to encourage multi-year awards to reduce the frequency of applications. They want to institute a pre-application statement of interest process where it would allow them to pre-screen applicants. So applicants would submit basically a short form statement of interest. The agencies would look at that and then decide if they could move on to a full application. Now, their logic here is that they're sparing, less competitive institutions from having to prepare resource-intensive proposals. That could be a good thing, but combined with the political review and some of the other or political appointee review and some of the other provisions, this could be harmful to potentially to some institutions. Also, an interesting one on conflicts of interest. This is a little bit more niche, but to the extent you have folks in your institution who are often moving in and out of government positions, this is going to be more important for you. So when you're applying, you would actually need to note as a potential conflict whether you have anyone that was employed by the federal awarding agency in the preceding 2 years before your application. So this is more of an administrative burden of having to keep track of your employees and where they've been over the last few years. On to the next slide. So termination authority, this is another big one in addition to the political appointees. So this would permit both agencies and pass-through entities to terminate awards in whole or in part when termination is in its interest, including, so when we're saying in its interest, what follows it after including is not exclusive, right? So including if an award does not effectuate program goals, agency priorities, we've already seen that, right? That was existing. But what's new is the national interest. Also, this last phrase of as they exist at the time of termination. So this is another way in which OMB is looking at what's happened over the past year and a half with the challenges to all these terminations. And they're really trying to buttress this language to try to prevent future litigation, because we saw a lot of focus on this because most agencies, when they terminated awards last year, were doing so because they said that the research no longer effectuated the program goals or agency priorities. And so this is really why they're trying to broaden this language. So this would generally apply to all discretionary awards unless there was some overriding statute that went against this particular language. And at the time of termination of a discretionary termination like this, they being the agencies, would only need to provide a brief summary of the reasons for termination. And if they were doing a termination in mass, like a whole program was being terminated, they would only need to tell you that. Like, they don't need to give a specific reason why your particular award is being terminated. Now, if your award were terminated under this discretionary provision, agencies would not be required, they could, but they would not be required to allow for objection, hearing, or appeal. They would only need to do that in the case of termination for non-compliance. So this is really important too in moving a lot of the power over to the government, making this much more like a contract, but also, taking away those appeal rights that you would typically have in a contractual situation. Okay, next slide. There's also a new temporary suspension authority. This is something else that was borrowed from the FAR. So this would authorize suspension of award for up to 90 days if the agency determines suspension is in its interest. So again, very broad. And during the suspension, the recipient would need to take steps to minimize the incurrence of cost. And during that period, the agency could decide whether to suspend or terminate. Now, it does say that if the suspension is lifted, agencies should, not must, but they should consider to seek to resolve any budgetary or schedule impacts that occurred because of the suspension. But again, that's not mandatory. Okay, and for the sake of time, I'm going to tick through the next a bit more quickly. We can go to the next slide. An interesting one is that this is now the proposed rule says that agencies could cooperate with third parties that are pursuing private rights of action against recipients. So this is really, almost in a whistleblower-like way, potentially inviting litigation, and it would allow the government to join in on that. And so we can speak about that more, but let's keep going for now. Also, some of these around DEI and anti-discrimination, I'm not going to pause on these because this is really putting into the proposed rule the EOs and things around anti-discrimination that we've seen over the past year, potentially broadening it. And obviously, it's different once it's in regulation. Executive orders technically are directions to agencies, not to awardees. But a lot of the concepts here are similar to what we've seen over the past year. And then the next slide. So international elements. This is another important one for those of you who do international research and have colleagues or partners outside of the US. So basically, this is creating a default position of a domestic first framework. So in general, as to R&D awards, they would need to be made to entities organized under the laws of the US, any given state or tribal government, to the extent permitted by law. And agencies now they can still provide funds or support work with an international element, and that's a term of art here. But there has to be some showing that it's justified, achieves program objectives, and is in the national interest. And we also see that in foreign collaborations. And really, we see this as an extension of the Wolf Amendment, not only to all agencies, but basically other countries, right, beyond China. And that's going to have a lot of implications for folks as well and needing to justify that work. Okay, and next slide. So subawards, a lot of this is really going to be more of an administrative burden on folks. So there are going to be enhanced reporting requirements, ensuring that in your performance reports, all subawards have been reported on sam.gov. Now, the second bullet is also very interesting that if you have any affiliates, subsidiaries, or related entities that are separate legal persons, so this is a separate legal entity, you would need to determine whether they were a subawardee or a subcontractor. You would need to do that analysis, and you would need to classify them as such. So some of you may have subsidiaries where you're not doing that analysis currently. They may be in some kind of, fiscal administrator relationship with you. And so that's something that will be an additional burden if it's passed as proposed. The third bullet is really another one where we're getting squishy language. So pass-through entities would need to ensure that subrecipients are not taking actions that significantly damage the reputation, not only of the pass-through entity, but also the funding agency or the US government at large. It is not defined what it means to have significant damage to reputation. And this would create another avenue for the government to terminate. So if this occurred and was reported to the government, they could decide to terminate the subaward or tell the prime to terminate the subaward, or they could just terminate the prime award as well. And finally, for those of you who have any fixed amount subawards right now, there's just a blanket statement now in the proposed rule that fixed amount subawards would be eliminated entirely. OMB says there's not enough transparency or oversight in those awards, and so they want to do away with them. Okay, next slide. Just very quickly, here's a list of the kind of what we're calling unallowable costs. So in general, for all of these, it's not to say that they're not permissible in all circumstances, but it needs to either be under some kind of federal statute or some kind of law that says you're able to get this funding, or it needs to be approved by the agency on a case-by-case basis. So it's starting from a position of a prohibition, but there is an ability to potentially get these costs if it's approved. Okay, and last slide here. Thank you. For payment justifications, we've seen a lot of this over the past year. This really isn't new, but putting it to the proposed rule here would put it in regulation, just making sure that recipients need to include justifications when they're requesting drawdown of funds. And then also an interesting one is disclosure of fraud and misconduct. There's already an existing requirement to report fraud and misconduct to an agency if an awardee becomes aware. But now agencies would be required to report that to Janine Pirro's office in DC within 10 days of receipt, which obviously is just showing kind of a potential enforcement mechanism that OMB is looking to. So I went a little bit longer than I wanted to, but I'm hoping that was helpful. Russ, do you want to go back to Yvette to do her portion and then open up for
I think
questions?
if Yvette is able to get on,
I am here.
awesome.
Can you hear
Oh,
me?
good.
We can hear you. Maybe Yvette, stay off camera and we'll
I
just.
am going to
Yeah.
stay off camera. For many
All right.
reasons, that's beneficial. So thank you.
Yvette, thanks for making the extra effort to join. And Leslie, thank you for that. And we'll come back to you. And I see your colleague Mark has joined. We'll come back to you, Mark, with questions after Yvette buzzes through her slides, which I think we have queued up and are ready to go. These are the slides on. Okay, so you're going to make comments. You just heard what this is all about, what's wrong with it. And I know there's some questions. And we'll get to the questions. But let's talk about what it takes when it's time to make comments. I think we can skip this slide.
Yes, we can
why we're
skip
here
this one.
because
We
we've
can go
done that.
right to 3. Perfect. And thank you. Thank you for your patience. Third time's a charm, hopefully. You already heard the reason why this is important. And slide 3 was just what's the difference between a request for information and a notice of proposed rulemaking. A request for information, which is very familiar to this community, is more of a dialogue and information gathering. And as you've heard in that wonderful summary from Leslie, this notice of proposed rulemaking is more like, this is what we would like to do. Just tell us that we're wrong. So it's less of that back and forth and idea sharing. It is, this is what we would like to put forward. And if you have any comments on this specific thing, then now is the time to flag it. So you are not going to change OMB's decision. This is what they have decided. You just need to provide data or information to highlight things that they might not have considered in the development of their NPRM. And that is highlighted here. Just why is this NPRM unique? It's the breadth of the changes, which again, Leslie highlighted so lovely. I'm glad I was able to join most of that. Also, the timeline for the comment period, 45 days. This is incredibly brief. Typically, a notice of proposed rulemaking that is meant to be obvious and not requiring a ton of engagement is 30 days, whereas something more extensive like this situation would be at minimum 90 days, if not 180. An example of a 30-day NPRM was making the rule highlighting that the NIH campus is smoke-free, tobacco-free. So that just gives you an idea of how short this 45-day timeline is, and that is what we've been given. Also, the timeline for implementation, the NPRM makes it clear that they would like to implement this for the start of the new fiscal year. Next slide. Why comment? Pretty sure you have lots of reasons already, and Leslie gave you even more. But thinking from the advocacy side, these comments are necessary for documenting the implications of the proposed regulations. And again, highlighting that short timeline, you need to highlight what the unintended consequences or potentially intended consequences are, and what the implications of this accelerated timeline would mean for anyone receiving federal financial assistance, including scientific researchers. This also allows you to go on record, and this, the way I've been sharing it with other groups, is it activates the other pathways to combat the proposed changes. Those of you who want to go to Capitol Hill and talk to your congressperson, the first thing they're going to ask you is, did you file comments? And so you are establishing that paper trail that you have engaged in all the proper steps, raising concerns about this notice of proposed rulemaking. Next slide. Things to consider when developing your individual comments. And I know we probably have a breadth of participants on this webinar, ranging from individual investigators to institutional officials. One thing I wanted to highlight at the top is coordinate with your institution. I've seen this come up in a few discussion points or papers or comments, but I really want to drive this home is that you need to connect with your institutional leadership to understand what efforts are underway for an institutional response, and also understand if there are any limitations on your use of institutional affiliation as part of your comments, or even the corresponding email. Because if you want to submit your comments and have your name attached, which I'll discuss in a few more slides, you need to be careful of, are you representing yourself or are you representing yourself in a professional capacity? Second point is to tell your story. Certainly, as Leslie was going through her slides, there are points that resonated with me personally and professionally as somebody who had a grant terminated. Tell that story of what happened when that grant was terminated in 2025, and who that affected, how that affected the science, how that affected public health. And you want to provide clear examples of potential negative outcomes. And then last, and I know this one has been shared a bunch, but I just need to reiterate it, avoid using the copy paste form letter. In the end, anything that looks like a form letter or overly similar, yes, there will be similar things that we all raise in our comments, but if it is the same text over and over again, that only needs to be counted by OMB as one comment. Next slide. So how to submit comments. Let me introduce you to my friend, regulations.gov. This is the file cabinet for the federal government, and this is where you can find everything related to this docket. And I basically just walked through and I took screenshots of this process for you so that if you read it through the Federal Register or you got there through secondary sources, you know where and how to get there. So when you get to regs.gov, you will enter the docket ID, which I pulled down at the bottom, and then you'll enter that in the search box. Next slide. And then you will get to this landing page. I have circled in blue. When I made these slides, I believe it was Friday, you can see the comments in the upper right oval. That is the number of comments that's been officially published. And then the lower left oval shows the comments that have been received, but there is a process for reviewing and posting those live. So you can always check those. I can give you updated numbers on those. As of about an hour and a half ago, there are 22,500 logged comments and 28,662 comments received. So keep it coming. You need a large response to this. Click forward. And there should be a new oval. And so then where the green oval is, this is where you can find all of the documents related to the docket, including the proposed rule, and then the required analyses that OMB had to provide as part of the regulation process. So next slide. Then if you want to file the comments, you go into the documents and you can see that you have two ways of getting to the comment button. The first one is, you went to the document comments and there's the button at the top, move forward. And then you can also go right to the document details and there's another comment button. So just keep clicking until you find the comment button. And then moving forward to the next slide, when you click the comment button, you get to the landing page. And this is where you're going to file your comments. There is a text box at the top that says comment. It is starred that it is required. You are not limited to this box, and let me tell you, you would be limited to this box because it is 5,000 characters, not 5,000 words, and those 5,000 characters include spaces. So this comment box should really be treated as an executive summary of what you plan to comment in attachments, and you can see that there is a box for attaching files. You can attach a variety of files, and that's where the bulk of your comments can live, but you do need to use that comment space, and I did want to make it clear that that's 5,000 characters, not 5,000 words. Next slide. Then once you add everything, then you have the option to declare yourself as an individual, an organization, or file your comments anonymously. This is where that coordination with your institution is very important, because if you identify yourself as an individual or an organization, there will be an email address attached to it. It's not going to be public with your comment, but it does provide triggers for OMB to get back to you and know who you are. So you need to determine who you are, and we'll just walk through quickly what that dashboard looks like when you apply as an individual. And we've got that highlighted on the next slide. So if you decide that you want to include your email and you want to identify yourself as an individual, you are required to provide your first and last name. The other information is not required. Next slide. As an organization, you're going to have a similar dashboard. You're going to define what your organization type is. That's a pull down. So if you're a nonprofit, a research institution, you designate that, and then you have to list the organization name. For both the individual and the organization cases, your comment will be posted publicly with your name or your institution name. And then the next slide will be filing anonymously. And so if you choose to submit your comments anonymously, you should also take care not to include identifying information in your feedback in the proposed rule. You may have written something and found out later that your institution wants you to submit your comments anonymously, or you may say, I don't want to have my name attached to it. Just think about what your comments look like in that context. So have you provided information about your institution or yourself that somebody generally could read it and understand who you are, because then you lose that anonymity. And then I'll just close with a couple of thoughts. If you are concerned about the potential implications of the NPRM, you should comment. And based on my email, my LinkedIn, pretty much everything I look at on a day-to-day basis, everyone is concerned, and they should be concerned, and you should comment. Just a reminder to connect with your institution and before going forward. Second, your comments should focus on the implications of the NPRM on the federal grant making process, not the perceived intentions of the administration officials. And I know that's hard. That might be a separate document that you save in drafts and keep for yourself. But you really need to have this approach that this is how this will affect the work, and not who is trying to enact it right now. And I think Leslie had lovely commentary on that as well. And then last but not least, finalize and submit your comments by the July 13th deadline. Russ opened with the fact that there had been laudable efforts to try and get an extension on this deadline. It did not happen. So that July 13th deadline, that is a hard deadline. So make sure your comments are submitted by then. And I believe that is everything. And I am going to stop talking before my Wi-Fi kicks me off again.
All right. Thank you, Yvette. Thanks for being so valiant and getting on. I wanted to talk about the last thing that Yvette was talking about. Leslie, when you sort of teed it up, you said things that OMB may not have considered in writing this draft rule. And I thought that was an interesting way to frame it. Is that a particular I picked up on that as a particularly helpful way to frame something with OMB, but is that how you would recommend doing it, or is that one way to think about it? Is that in statute how they should be thinking about it, as comments are helping them think through things that they didn't think through? How does that work?
Oh, well, I'm not sure actually, Russ, which of my comments you're referring to there, but maybe on the fact that, they're making this regulation now, and Yvette got to this point at the end. They're making this regulation now under this administration, but the political appointees are going to change over time. Is that what you were referring
No, I
to
think
as the long-term?
you said in framing your comments about OMB may not have considered the implications of this, or something like that.
Oh, yeah. Well, I think in general, though, OMB has its own kind of agenda, right, and what it wants to achieve. It has a stated agenda and maybe some other things in the background that aren't quite as transparent. But you all, as folks who actually receive this funding, are doing really important work. You're going to understand the implications in a way that you need to express to them. And so Yvette made this point too. In your comments, you really have to give salient examples of not only how you all have been affected by terminations over the last year, but how some of the provisions and the potential uncertainty that's being injected is going to affect you in the long term and your ability to do the research over the long term. So I think it was more an emphasis for us on just
Got it.
perspective, right?
Perfect.
And getting that through.
Perfect. Mark, you missed a little bit of Leslie's great presentation, but you did hear some, and you heard Yvette's. Anything you want to add, subtract, modify?
Russ, yeah, sorry I'm late. I was detained at another meeting, but thank you guys for inviting Leslie and me. And yeah, I did hear a good bit of what went before. I would just add to answer your question and what Leslie just said. Remember that the people who wrote this at OMB, they have already thought in their minds when they wrote this that we as a community, as a research community, are going to object to this because it means that it's undoing the way that we've done business for 50 years, really even since the end of the Second World War, when NIH funding was greatly increased and started going out in great quantities to universities and medical centers. And so they've already rehearsed in their own minds when they wrote this all of their answers to our saying this is going to disrupt research. Is going to mean that we won't have any certainty in what we do. They've already anticipated that. What they've not anticipated is and what therefore they're going to be challenged by in writing a response to our comments. And they are required under the Administrative Procedure Act to write a response to every set of substantive comments that they have not already anticipated in their introduction, in the preface to their proposed rule. They're going to have to respond to that. And so anything that we can say that essentially goes into the tertiary and quaternary indirect unintended consequences of what they're doing will be a challenge for them, and they will have to deal with it, and they will learn some things that they wouldn't otherwise know, which is good in a substantive way. It's also good in terms of a future legal challenge, because if we are able to bring up points that they actually haven't considered and to which they don't have a good answer, that forms the basis for ultimately a potential legal challenge to the final regulation. So, I mean, I'll just give you one example. And Leslie, you and I haven't even talked about this example, but one of the things that I'm sure Leslie covered in her summary slide was the idea that sort of the America First. Agencies can only give grants to American institutions unless there's some compelling reason, and then there is a requirement that we as recipients and as PIs not use any federal money to support a bilateral or even a multilateral collaboration with the foreign country of concern. So one question is, what's a foreign country of concern? The definition is so broad that we would have to, as a community, comb all of the statements of the U.S. State Department leadership, as well as the national security agencies and everything else on a daily basis to figure out who's disfavored, what company is disfavored, because it's a very broad definition. The second thing is it says we also, not only can we not use direct funding, direct federal funds, we can't use indirect or IDC funds for that. Well, how in the world are we supposed to have an accounting system that makes sure that the IDC funds that go to the general counsel's office or the audit office are never expended on anything that it's at all related to this broad variety of companies and countries of concern? So these are things that I am sure they have not thought about. So just to give you an example.
Thanks, Mark. And that last one especially is really, really useful, right? It's something that they clearly can't have thought about because it makes no sense. I'm going to start going through some of the questions. And folks, if you have questions we have Leslie and Mark on the screen, but I can see that Yvette is still here. She's just not able to be on video. So I'm going to try to run through as many of these questions as we can. We had at one point over 500 people on this Zoom. We're probably not going to be able to get to every single question, but if you put them in the Q&A part, that's more helpful to me than the chat, just to make it easier. So first question was, comments coming from non-U.S. citizens. Are those helpful, counterproductive, irrelevant? What's the rule on them looking at comments from non-US persons?
Well, Yvette may want to comment on this, but I'll just say that there's nothing wrong with that, and they have to consider that. That's not a problem. There's no disqualification of comments because it comes from a non-U.S. citizen or a non-U.S. Green card holder, for example. But I would say that the most important thing the most important kind of comment that could come from that kind of person, from a person or an entity in that category, would be to explain how vibrant, important scientific research is going to be disrupted in an international collaborative sense by these rules, and give hard examples of that. That would help. And also to comment on how that is going to harm ultimately the international economic interest of the U.S.
Yeah, I think that, Mark, is the most important. If you can tie it back to the US and this, the new term, the national interest, that's arguably harming the scientific community in the US to not have these important, really fruitful relationships with folks outside of the US and doing, even US entities doing work outside of the US. So.
And I agree. And actually, there's nothing in the form when you submit to regs.gov that says, are you a US citizen? So unless you document yourself in your comments that you're a non-US citizen, they wouldn't know that based on, even if you went on the record with your name.
Thanks, Yvette. Okay, next question was shift from guidance to regulation. I'm going to just read this question out. It's a bit hard to wrap my head around, as my understanding is that the uniform guidance originally was intended to standardize what used to be different circulars for universities versus states versus agency X, et cetera. What parts of the uniform guidance prior to these proposed changes are already government-wide, and what aspects have been agency specific?
So it might help to just talk about how everything sits within different areas of regulation. So the uniform guidance, when it first came about and first introduced in 2013, finalized in 2014, it sits in 2 CFR Part 200, as you all know. But it expressly says in its preamble or around applicability that it is not a regulation. And so each agency that wants to adopt it needs to do so in its own regulation. So in subpart B of Title II, you'll see if you go to that section, it's kind of a laundry list of agencies, starting with HHS, who then have codified the uniform guidance. So they say either we're just adopting it in full as it is, or an agency like HHS, historically, this is no longer the case, but historically, they restated in full the uniform guidance and changed terminology, changed certain dates to make them more restrictive. And so it required that extra action by agencies. And so what OMB is trying to do now is saying, we're trying to get rid of that extra step. And so we want to modify that language in subpart B, where everybody's been codifying the regulation, to make it such that in the future, when we make other amendments, we being OMB, they're just going to be effective when the rule is finalized, when future rules are finalized. Agencies will not have to take extra steps. To the question of does this apply government-wide? Not all agencies have adopted the uniform guidance. Most of them that are important to you all have, right? Either in full or with some modifications. But in the preamble or the comments that OMB gives in this proposed rule, they specifically talk about the fact that agencies that don't currently have a section in subpart B will be added there. And so this is meant to be kind of we're calling it OMB's rule, but the final rule, OMB expressly says, will be not only their final rule, but all of the agencies that are listed there. So, but Mark, do you have anything else to add to that?
I think the bottom line here is that the guidance was the previous, or what's in place now. Agencies can vary from it if they want to. This rule, agencies will not, in order to vary from it, agencies will have to make their own regulation, and that regulation will have to go through the entire White House and OMB review process before it's adopted. So what we are seeing is really a rule which was guidance essentially be transformed into binding law on all agencies.
Right.
on all agencies. And that was actually a specific question we got. Is, are there any agencies that are exempted from the rule? Any types of awards exempted from the rule? I think the agency answer is no, but what about types of awards?
Well, remember, contracts are under FAR, and
Right.
and there are individual agency. So if agency wants to do a contract, it can just do a contract. And in fact, we know the DoD and ARPA and DARPA and there are other agencies that often work through contracts and not through these grant rules, right?
Yep.
Yeah. Yeah. But there's no specific language saying that there's any deviation from what would typically fall under the uniform guidance. So grants, cooperative agreements, really anything that's not under the FAR.
Okay, perfect. So you're either under the FAR or you're under, if this passes, if this finalizes, you're either under the FAR or you're under this if you're getting federal money.
Usually, I'll say there are some exceptions like other transactions agreements, OTAs, which provide a lot of flexibility.
Yep.
Sometimes they just pick parts of these provisions, but that's an exception. So in general, I think that's right, Russ.
Okay. This is actually a question that's come up a lot on a lot of calls. What about an organization submitting more than one comment as an organization? Originally, there was folks saying if you submit more than one comment, they only have to look at one of the comments that your organization submits. And then other folks have been saying, no, that's not actually how it works. I don't know if that's a part of the APA or if that's a practice. What's the answer to that as best you all understand?
My understanding, I don't think there's anything in the APA that is that specific about multiple comments, either from individuals or institutions. We do know, of course, that in many cases, we're all members of particular organizations. The organization files their comments. We file our individual comments. Our university files its comments. It, goes on and on. I have never seen and I've looked at these things for decades now. I've never seen an agency response that two comments saying we received 5 comments from the University of X and we're only considering the first one we received. I've never seen that.
Thanks.
Agreed. I've never seen that as well. And usually, as long as there's enough distinguishing components between the comments, you should be fine. I mean, if you're just submitting the same comment 100 times, that becomes problematic. But if you're using it as an opportunity to address different components each time you're submitting, you're fine.
Okay, here's an interesting one. I hadn't heard this before. Someone says there's a concern that comments will be disregarded when posted through regulations.gov. Is this valid? And if so, there's a group that's publicizing an alternative site through which they are tracking in case there's a need for legal follow-up. So I guess my read on this is if you don't post to regulations.gov, it doesn't count. You have to post to them. So maybe it's a question about should you also be posting to this other site? Is there, last time I did anything with regulations.gov, it's all there. Like you can literally see, I guess that had a screenshot with 18,000 comments. You could, if you have time, read all 18,000 comments. There is a transparency there that your comments are there. Now, whether they do look at them and how well they look at them, et cetera, but I don't know that do you all, Mark, Leslie, this is about, sort of laying a predicate for legal action. Is there any worry that they'll sort of just disappear into the ether?
No, and I think in terms of where to submit, I mean, and Yvette may have thoughts on this, but make sure you're going through the official channels. Like, I can't speak to these other sites or groups that have popped up. But if you're going to submit in other areas, you should do that in addition to the official regulations.gov process. So, Yvette, do you have other things to add there?
Yeah, no, I thank you for lifting that. Regulations.gov is if you follow the instructions of the NPRM, the comments are to be submitted through regulations.gov. That is the official record. I called it the filing cabinet of the U.S. government. You want to make sure that your comments are there. I am skeptical of secondary sites they're routing through because you only know if they've gone through regs.gov if you've submitted them there. If what you choose to do with them afterwards is at your discretion, but you do need to go on record that very strong. In my opinion, that's where it needs to live. That's where it will be analyzed. We cannot control what the agency will do after it receives those comments, how it processes them, but that's the official channel.
Thanks. I think that's certainly been my experience as well. There's a question about severability. Can parts of the proposed rule go into effect without the whole rule going into effect? I think they have explicit language in the rule that says yes. Is that wishful thinking, or is that sort of standard practice with rulemaking?
Yes, so that's standard. So it's not an all or nothing. So the agency will take in the comments, review all of them, and they can make basically further changes based on that. It could decide to adopt in full what they had proposed in some sections. They could decide to rescind in others. They could actually make new modifications that are taking into account the comments and the concerns. So it's not you must accept in full or not. It's a good question. Yeah.
Thanks. All right, I'm going to read another one because I'm not smart enough to summarize this detail quickly. In the section on transfers to related entities, do you have concerns for institutions that have an affiliated research foundation that applies for and accepts federal awards and then transfers the funds and responsibilities to the institution? I think now those institutions typically treat it as a transfer, and for proposal budget reporting and other purposes, treat the institution as the prime rather than the research foundation. So that does feel like an odd pairing with this transfers to related entities thing. Is that something folks should make sure to comment on?
Yes, they should definitely comment on that, because I think that the folks who wrote this are not aware that many academic medical centers, research institutes, and universities, they have segregated their research funding. They've segregated, in some cases, their tech transfer and the royalties into a separate organization, which is fully controlled by the university. The university is, in most of these cases, is the sole corporate member of the research foundation, and it's really the alter ego of the university for these purposes. And I think they have not. The writers have not contemplated this. We need to inform them about that.
If this goes into effect as written, Mark, what would that mean for institutions that sort of follow that as a normal practice?
Well, it means that you end up with you're sitting there at your children's hospital with your research foundation, and so you're going to have to, the research foundation, if it's receiving the money, or the children's hospital, if it's receiving the money, has got to treat the other entity with all the bells and whistles as though it is a subawardee. So it's got to do diligence to make sure, and documented diligence, especially to make sure that it's able to do the work. It's going to have to negotiate a subaward agreement with the institution. It's going to have to monitor the subawardee. I mean, in other words, it's not only belt and suspenders, it's belt and suspenders times 20 in these cases, because the university already controls the foundation. So that's the problem. It is bureaucratic make work, which is what this administration says it's against and wants to cut down on. That's part of the efficiency argument in the introduction to this proposed rule.
Well, that might be worth, as you write a comment, referring back, because I think it is in the preamble, right? That they're trying to reduce administrative burden.
Yes.
So for a comment on this one, it seems like it's going contrary to the purposes of the stated purposes, not just the purposes, but the stated purpose. There's a couple questions in here about the impact of comments based on where they come from. It's institution, individual, anonymous. Do anonymous comments get less weight? I imagine there's not a statutory distinction between these. Yvette, do you have any idea if there's a practical distinction?
Being on the receiving end, it's more that's how they get binned, or at least if I were staffing this on the other end and looking at what will likely end up being at least 50,000 comments, if not more, you bin them and you start to see the themes. There will be the recurring themes across all three categories. But there was the question that came through, and I'm glad you lifted this. Just because you file anonymous does not take away the weight. it does help if you are able and in a position to put your name, or if you are an organization, to use your organization name, but your comments will still hold weight, and it's more how they are categorized behind the scenes.
Thanks, Yvette. I'm going to ask one last question. I know we are right at time, but I'm going to ask one last question, which has come up on basically every webinar I've been a part of on this. And Mark and Leslie, this is for you. Can they do this? Legally, can they do this?
Well, I mean, they can do a lot, and they can do a lot of this. There are some things I think that are, and Leslie may have, and you guys may have talked about this before I joined, but there are some things here that run up against First Amendment freedoms. There are also some features of this that are so ambiguous that it just doesn't meet due process, either in the way it's expressed or in the application. So, for example, the proposal that the political officer is able to forbid things or not agree to fund projects that are anti-American in nature. Well, there's no definition for what is anti-American in nature, for example. So I think there are some significant potential constitutional and maybe even statutory, like the APA, bases on which to challenge this. But much of what they want to do here is achievable. But not all of it. I think some of the more extreme things are features of this are probably challengeable in court, and that's one of the reasons why people should and institutions should comment, because the more that there are comments like this, the more that when lawyers like us go to court to try to challenge this, we are going to cite those comments. We are going to explain why that 49,000 of the 50,000 said X, but this was not taken account of in the response. So it really makes an important historical record. It makes an important a record for congressional representatives, and it makes an important record for potential legal challenges.
And we'll have to leave it at that, Mark. Thanks very much. There will be potential legal challenges, and there's certainly political work that we can do. But first, let's get the comments in. Thank you all for joining. Thanks for the questions. Sorry we couldn't get to every single question, but I hope this was helpful. We will be together again next week. I'm not sure exactly the time yet. I don't know that we've lined up the exact date and time, but we will continue to get together as long as necessary to bring the community together and shine light on this proposed rule. Mark Barnes, Leslie Thornton, Yvette Seger, thank you very much for joining us, and we'll see the rest of you again soon.
Take care.
Thanks all.
Thank you.